the LAProbate expert, and this is our probateweekly.com live stream. We do this every Thursday, 4 p.m. Pacific time, 7 p.m. Eastern, and everything in between and on either side. We get together every week and interview attorneys, vendors, successful real estate agents, investors, anybody who's involved at a high level of working in the probate real estate space to teach us all how to make more income, make more money, and in the long run, build more wealth and also be a better service to our customers in the market around us. So we do this every Thursday. I'm a real estate broker here in Los Angeles. I'm building a national team, and so but there's no charge for this call, and really just do this to share as a mastermind. I started this call because I needed it. I needed a place to share and to learn and to bring people in that I wanted to learn from, and so we built this into what I think is the largest probate real estate live stream in America today. And I'm really proud of that. Appreciate all you guys who are regular supporters. Thank you so much. You can subscribe to this. You can join probateweekly.com, and we'll send out emails and text message reminders if you want to come on to the Zoom call. We're also on live stream on YouTube and Facebook. You're welcome to follow us there. Subscribe onto YouTube. If you like what you see on YouTube, please hit the like button. We're looking to build our YouTube presence. It's a great tool for us to communicate with our customers and with the real estate agents and to get good feedback on the content. The goal of this is to be participative. I bring on people to interview, and I purposely use the Zoom format because I can get 100 people on at one time. And you can ask questions if you come in. You can either put questions in the chat box. I have a couple already. You can promote your business in the chat box. Glad to have you do that. And you also can raise your hand. I'll call on you and or jump in and ask a question live. It's meant to be participative because the more we participate, the more we are involved, camera on, ask questions, get involved, the more we learn. And the more you learn, the more you help everybody around you learn more. So it's meant to be participative. So feel free to jump in. If you're watching on Facebook or YouTube, feel free to put questions there. I'll either get to them live or circle back after the call. But if you want to participate live on the call on Zoom, we only have room for 100 people. And we usually fill up at some point, and then it kind of bounces around 90, 95 or so. So love to have you guys on the call. Our guest is an attorney. She's running a little late in Southern California, but she's a great guest. It's somebody I've done a lot of business with and really want to share her insights to you guys. I think she'll be very, very valuable for you if you're looking to build your business as a real estate practitioner or investor in the space. So let me just go real quick, answer some questions up front, and then feel free to ask any other questions in the chat box while we get started. Eva asks, is it important to have the case number when you write up the listing agreement? Eva, are you in California? I'm going to assume the answer is from Lancaster. Yeah. So in California, we have the California Association of Realtors. We use now the regular residential purchase agreement with a probate addendum. We used to have a separate probate purchase agreement. We don't have that anymore for residential property. In the probate addendum, it will ask you for the case number. It'll also ask you when you have a signer who's an entity signer on a purchase contract, you want the case number as well. But is it essential that you have the case number? I don't think you have to have it when you sign the listing. I don't think your listing is invalid without it. I would say ask your broker how they manage that. But I would say at our company, I believe if you have a listing agreement and left off the case number, it's still a valid listing contract, but it's more precise. And I think one of the things that I try to teach on this call is there's a right way to do everything, and you want to do the right way. And one right way is have the case number and have it on the form and maybe even look up the file or have information from your client about the case. So I would say it's the right way to do business is to have the case number on the document. Why not? But I would definitely not listing the property until I have it, right? That's a personal decision you can make. And I would urge you to talk to your particular broker on how they hold on this. Okay, so we're going to turn off, unmute themselves. We're going to let people do that. Okay, good. So hopefully that answers your question, Eva. But again, I think it depends on your broker. With the XP Realty, and we could take the listing, but I would say it's not the right way to do it, and we're going to get it amended at some point when we're there. Sandra says hi from Burbank. Hey from Burbank. Great. Kelly Conley from Long Beach, down the 562. Kelly, always great to have you on board. Feel free, anybody who wants to put your information in the chat box. It's meant to be referrals. It's meant to be helping each other. If you're a vendor as well, if you're a lender or a title rep, feel free to reach out, put your information in as well. Karen's amazing from the OC. I grew up in the OC, so I'm definitely all for that. Question for attorney guests: what authority, if any, does the order for probate provide They're not provided by the letters of administration. Wow. So I think you're going to find that the letters of administration document the authority, and on the order that the judge signs, it's going to say limited or full. They're just going to check the box. And then from there, you're going to have to understand what the law means for your particular client. But we'll ask Mina when she's online to give more detail. But I would say that the letters of authority are more of a form, and on the actual probate order, it has the checkbox for full or limited. And then those are the two types of, as far as we're mostly concerned with as real estate agents, the sale of the real property, the full authority generally means you don't need to have court approval, though that can change if there's objections. And limited authority almost always means you need court approval of the sale of property. And so that will determine there the type of authority that the court grants you. Hope that answers your question, but we'll ask again when Mina's on. Alex asked, what's the most effective way to prospect probates? So Alex, where do you do business, Alex? Because I would say the answer to that, having done this myself for a while now, LA County, okay, so you're a neighbor of mine. I would say that having done this for a while, it varies based on where you are. It varies based on your market, and I'd also say it varies based on your business, meaning, I say when you start out in real estate, you need to talk to a lot of people. Generally, you need to cold call 3 hours a day and talk to as many people as you can. And by doing that, you'll learn how to convert the leads you do get into business. So I would always urge somebody who's new in the business to start with the phone calling or emails. I would say the emails are probably of limited value because the few that have emails get so much attention that they're going to probably disregard, it's going to go to junk. And by definition, you're spamming people because you don't have permission to email them. So I would say I'm not aware of anybody who's built their business emailing probate attorneys or probate petitioners via email. I do know several based on phone calls. I've done it myself and done well with it. So I would definitely recommend making phone calls. I might add to that you might send out postcards, but my rule would be not to postcard anybody that I'm not also in contact on the phone with. I would never mail something to somebody that I couldn't also call them back. Okay, Eva says, I have 4. I don't remember what 4 is. What is that an answer to? Eva from Lancaster. Oh, you have 4 listings or 4 properties? Is that what you're referring to? We've got a lot of questions, so it's kind of hard to keep up with her. Eva, I'm not sure what your 4 has to do with, but 4 case numbers. You have 4 listings. Okay, got it. So yeah, I don't think you need the listing, but what I will say is that technically speaking, a listing is not binding on the signer until not only they have a case number filed, but the court gives them the authority to sign the contract. Because think about it, the person's owned by, let's say, Joe Smith and he passes away. If Joe Smith passes away, he can't sell his own house. That's the definition of probate, is you need the court, and there's our guest, Mina. By definition, they can't sell their own house. So if you haven't filed probate yet, it's difficult because the person who owns the property has passed. They file the probate, and then they are able to seek authority from the court. Once they have the authority, they're then able to sign a binding contract. And so there's a question. In fact, that's one question I'm going to ask Mina about signing when you don't have the contract. Mina, welcome to our call.
Hi, thank you for having me, and I apologize for being late.
That's okay. Well, we know you're busy. I'm not paying your full billable rate. I'm not paying your normal stated rate or whatever you call it. So I can't afford to be too particular. It's always great to see you. Mina, how are you doing?
I'm well. How about you?
Good.
Nice
You
to see you.
You travel quite a bit. I know you had some COVID stuff. You had some good family stuff going on. We've been talking a long time. So I'm really excited to have you on. And we started kind of answering some questions up front, but let's kind of go back to the beginning here and start with you. Can you give us a little background? Just where did you grow up? And then how did you get into law? And then how did you get into probate specifically?
So I'm originally Iranian. I lived in Iran till about when I was 12 years old.
Wow.
Then my family moved to the United States after the Iranian Revolution. And at some point, my father got a job in Los Angeles. So we ended up here in Los Angeles. Now, that was many, many, many years ago. But that's sort of how things got started with me, being here. And what else did I want to tell you? What was the next question you had? I'm sorry.
Well, let's talk about how you got into law. I mean, I think every Persian family, you have to be a doctor or a dentist or attorney. Is that the rule?
Yes, yes. They don't want you to do anything else. Actually, that's sort of true. Um, I couldn't be a dentist. My mother was a dentist all the way till she turned 85 years old. She practiced.
Wow.
I couldn't take it. I couldn't stand blood. So that was not the career for me. And I had a couple cousins who were lawyers. So I decided to try to see if that was something that was suitable for me. But I originally wanted to actually become an architect, and my father wouldn't have it. So that's how I ended up in law.
Wow. And so, and then how'd you end up in probate? Because you are what I would describe as the type of attorney that we want for business to, that you specialize in your case, even specialize. You're in probate, and then within probate, your husband does more administration and you focus more on litigation. How'd you end up in probate specifically?
When I was in law school, I went to school at night and I worked during the day. So I worked for a gentleman who did estate planning and probate. So that's all I learned how to do. And when I was looking for a job, just after I passed the bar, people wanted to give me a job where workers' comp lawyers or PI lawyers, and that was not something that I was interested in. So I decided to give it a shot, and against my husband's former boss's advice, I decided to set up shop.
Wow.
And after about a year, things were working and I was getting clients, and my husband then left that firm and joined me. So that's how things got started.
Well, is there some relationship between the two attorneys there? Be careful. Sexual harassment, you know how those laws are today. Be very careful.
Well, we were already married by that time, so it was a little too late for that.
Well, it's not too late for that, actually. You're married, so hopefully it's a good thing for you guys to play in the office or something. So good. So, and then I think I had that correct, right? You guys, as a law firm, when I go to your website, it just says Los Angeles Probate, Sirkin Law, that you guys are firmly in that niche. And I think as a real estate agent, there's nothing worse than having a client who calls me up and says they want me to list the house, they're in probate, they have an attorney already, they're already filed. I search them online and I see that attorney specializes in DWIs, family law, probate law, criminal law, 15 other things I never even heard of before. And what I came to learn in my experience in the court was that the best attorneys are the ones who really specialize in a niche. So you've gone all in on this. Was that a business decision, or it just worked that way for you, or how did you end up?
It just worked out that way. It was not. It wasn't anything that we could say was intentional, but we both sort of. My husband came from a real estate and business background, and when he joined my firm, he was at the time he was involved in that sort of thing, but quickly everything sort of shifted into planning and administration, and with planning and administration always comes probate. So it was a very quick shift in terms of what we were doing, but his practice started with another firm, so he brings with him some of that experience as well as trust and estates litigation.
And I also think I ever told you this, but I really learned a lot from you about networking at the court, because I noticed how you have relationships, deep relationships, pre-COVID with the other attorneys in the probate bar, and as a result, got referrals from them, gave referrals to them, like things that you didn't do, things that they don't do. I just noticed but it was really natural. It wasn't like you were on the hunt for business, you were just developing relationships. Can you talk a little bit about that process? Was it natural, or was it?
It was very natural. Some of it is obviously, conscious, but I think most of it is natural. I think you have to like to make friends in whatever area you practice in, whether it's real estate, whether it's law, or any other business, and figure out who's doing what that you're not doing, or what complementary businesses are sort of on the side of what you do that you can help other people. And, over time, those people will refer back to you. And I don't think one can expect an immediate return from networking. If you're expecting that it be immediate, that's not how it works, at least not hasn't been my experience. My experience has been that it takes, 2 to 3 years to build these relationships. During COVID, it was kind of hard because, I haven't been to the courthouse in since COVID started, but I have to still maintain the same relationships with the same, set of people so that they benefit from my services, and over time, perhaps they refer back to us. So you have to find other ways to network.
Right.
Some of the networking comes by, picking up the phone and calling is always a good way, and trying to figure out how you can be of service to the other folks is really the key.
Yeah.
But Bill's a master at networking. I've watched him at the courthouse. I know how he does it. He does it with intention. I'm more like on the periphery of intention, but Bill's got an agenda. He's got a plan of action. He's got a list. So if you're a realtor or in the real estate business, follow what he says. What he says works. I've watched. I was one of his victims, as he would call it. So I actually I met Bill at the courthouse when he was doing his networking, and that's how I was able to do business with Bill. But I joke with him and I say, one of his victims, but I think that I benefited from his service to my client, and my client was very happy with his services. In fact, that case just went into, basically went into probate today after, 3 years of litigation. But one of the things that I watched Bill do is I watched him figure out how to deal with a possible foreclosure. That's something that we were facing. And he came in and rescued that case from an inevitable foreclosure and got things wrapped up so that we were able to sell it while in probate and while the two people were actually fighting with each other. So
that was a crazy one. Still is a crazy one. I guess it's still ongoing.
Yes, it is ongoing, unfortunately, because sometimes people just can't agree to anything, even if the judge orders them one way or another.
One thing amazes me, I'm sorry. One thing amazed about you in attorneys in general, I think that you're very good at this, you're a master at this, is that on one case you're litigating against somebody, right? So here you're the hired gun to financially maybe ruin the other side or cause them harm from their perspective. In your case, enforce the rights for your client and get your client what's fair and just. And you do it, you have to do it in a way that you do your job professionally. You can't, you have to have the proper lawyerly demeanor in court and in the process, or else the judge is going to get on you. But you also, in a way that the other attorney seems to appreciate and respect you more, not less, at the end of the deal. I think with realtors, the nature of real estate agents is we go so quickly to emotions and so quickly to fighting, and it just seems that it's more common amongst attorneys in particular to kind of hold on to that or not show it to each other somehow. And in your case, to build a relationship so that attorney down the road says, hey, Mina, I don't really litigate. Can you help me with this client? And that becomes business for you. Where does that come from, or how does that happen? Or is that just something you develop over time?
Well, first of all, I think there is a sense of respect that goes on, with the other parties, with the other opposing counsel. I think you have to have some respect for what they do. We are hired guns. Everybody that represents somebody is hired to accomplish a particular end. Nobody really wants to destroy the other side. I think that's a perception from a client's perspective, but that really isn't the way that things work in real life. Is that if you go all the way out to destroy somebody, deals don't get made, cases don't get settled. You end up in trials, unfortunately. Sometimes that happens anyway. But I think that if you have a rapport with the other side and you can help settle the case, number one, a settlement gets your client what they need faster, okay, and at a lesser cost. I think those are forgotten things. Sometimes in the midst of emotions, clients forget that.
Right.
And they want to go all the way to trial not knowing how much the trial is going to cost. But from an attorney's perspective, we're here to close the case. We're here to get everybody. Nobody likes exactly what happens in a settlement. Nobody is happy with the exact amount of the settlement, but it's something everybody can live with. So we encourage people to go to mediation, and often enough, it is a subtle art of rapport, but a forceful representation along with rapport. So it's kind of a mixed bag of things.
That's why it's called settlement. It's not win-mint, because both sides don't win. Both sides have to settle to get to the middle at some point. One question I love to ask attorneys: have you seen the movie My Cousin Vinny, and what are your thoughts of that movie?
I love the movie. I thought it was great. I really enjoyed it. I think I've seen it more than one time, actually.
Okay. To your recollection, is that a fair way? At least the judge is trying to enforce a certain lawyerly demeanor. I try to tell real estate agents, when you go in court, you want to act like an attorney. You want to dress like an attorney. You want to act like an attorney. You want to know the rules. Is that a fair representation of that? I know it's comedy, but do you see it that way?
It is a fair representation. I think no matter where you are, I think whether or not you're in court or you're in any kind of business, you want to blend in with the rest of the folks. So if the judges are used to seeing you with a jacket on, although now the requirements is somewhat looser, they prefer that because it's also a sign of respect to the court that, you put a jacket on today. That means that you went that, you put that extra effort. So if you're a realtor going to court, I think that would be helpful to you, doing that.
I was on the case I did with you that you talked about where I think technically it was the temporary administrator, so I was technically representing both sides as the realtor. I was called as a witness. At that time, I was in Florida on vacation with my wife, and I packed a suit and a white shirt and a silk tie so that when I was called in, and it was brief and it wasn't a big deal, but to go in front of the judge, I wanted to look appropriate because the judges remember you. And I think one of the things, on a small level, I've had judges I've been through several times, and I've earned a certain amount of respect and appreciation. And I know you as well. You've been in front of judges, and I've seen them say, because of who you are, they'll make an agreement or they'll make a concession or they'll trust you for something. So talk about the value of the reputation that you have with the judges. Now, it's more difficult, obviously, with the video versus being in court, but I'm sure it's still important to your practice, isn't it?
It is important. I think that there's a sense of trust that comes with many years of practice. I've been doing probate for 30 years. So I have seen most of the judges at least several times, and we have 10 probate judges in LA, just in the downtown LA, and not counting any of the periphery, the outer courts and Antelope Valley. So, you come across the same people over and over and over again. There is a sense of comfort knowing that, sometimes they've seen my papers go through before, right, and they realize that, these are standard things for us. Just like anything else. I mean, if you went to the dentist and you went to the same dentist for 30 years, there is a level of trust between you and the dentist. That's another professional, but, it would be somewhat the same concept because the judges look at us as people who are professionals in their courtroom. So I think, there is a sense of trust that, I'm certainly not one of those people who'd be trying to do anything. Most of what I do is pretty, simple and straightforward. And what isn't simple and straightforward has to be put in papers based on some law, right, something out there.
Right. But I mean, I've seen judges.
I think
there's a little
you
bit
would
discretion.
appreciate.
I'm sorry.
I'm sorry, I lost you for a second.
You're saying that I would appreciate.
I think you would appreciate being in front of the same set of people yourself, because there is a level of comfort when you've appeared in front of the same judge, let's say 10 times. You kind of know their demeanor. You know, right, what they expect.
Right. So now this is a little sensitive. So if you want to bow out of this question, I get it, but I have to ask it, at least try. So having gone to court quite a bit and also having watched video, now you can see the whole case being called more easily. I recognize attorneys like you who are knowledgeable and experienced and know the flow and know the procedure and follow the procedure. And I'm sure, like me, again, if you're not comfortable, you also see those that aren't. You see the attorney who might be one of the world's great attorneys and one of the great legal minds, but maybe has never done a probate case in Los Angeles County ever before, and is stunned when the judge asks things like, have you checked the notes? And they go, well, what are the notes? I've seen that happen. That's like the classic. So you see that taking off your hat as a businesswoman, but maybe just talking to families that are considering hiring an attorney, what should go into? How do they evaluate from the outside the right attorney, and what should they do to avoid what I see is it could be a great attorney, it could be a great human being. They just don't know what they're doing in probate, and it affects their outcome. I see that all the time.
I think there's about 3 different levels of experience in any field, given whether it be law or anything else. And I think you have to ask yourself the question of, does the person have the requisite experience I need? Sometimes people come into whether it be a probate case or any kind of case, believing that they can use this lawyer to accomplish a limited end of things, for example. And sometimes people will select a younger lawyer because they tend to charge less, et cetera. With that, of course, there's, experience has a value. So sometimes you get a young lawyer, maybe they'll charge you, X dollars per hour, but you may pay for the learning over time.
Right.
Sometimes you go with a middle of the road lawyer with, relevant experience, and, depending on clients' willingness to pay, they may or may not be willing to pay. And then you have the third level, which is, hiring a specialist. Hiring a specialist is expensive in any field, but you don't pay them to learn. That has been done before, so you are getting the benefit of their experience in exchange for their hourly rate, whatever that be. But I think a good question in any field would be, where are you in this specific experience that I need? How many probates have you done, for example, to completion, not just the beginning?
Right.
How many sales have you done to completion? Those are 2 different things. I can do many different probates and not do a single sale. That's sometimes a large possibility. And then depending on whether or not you have a case that has a simple litigation, that's another set of requirements, and then one that has a complex litigation, it has the different set of requirements. But sometimes you have to pick and choose between a small firm and a large firm. And those 2 also have different requirements. So sometimes, if I am going to bring somebody a case, I'm going to have to evaluate whether or not my small firm is going to be able to do all the things that this particular client needs in a case. So that is one set of questions that I would ask myself. And then I would ask myself, if I send this, for example, to a 50-person law firm, is the client going to get the service that they're going to need? Because a 50-person law firm may charge $750 an hour or $850 an hour. These are all, different possibilities. So it's a balance of experience versus hourly rate versus size of the firm. I think those 3 things are the ones that I would look for.
Great. So talk a little bit about the difference between a probate administration attorney, which I think is your husband in your firm, and a probate litigation attorney, which is you, as I understand it. There are people who meet somebody, but they need litigation, and they hire maybe a one-person firm only does one of those. What's the difference that you see as a litigator versus really doing administration?
Okay. So when you do administration, whether it be in trusts or probate, you are following just a set of procedures. When you're doing litigation, it's dynamic. It changes from day to day. What you need to prepare for, what motions are going to be coming your way, are different in every case, and it may vary 100% even in one case. So the people who do administration, they deal with just a set of tasks and getting the people through the process to the end. The people who do the litigation, they have to be prepared. There's a lot of adrenaline involved in litigation, so a lot of sleepless nights.
Yeah.
So if you have a case that requires motions, or being able to be prepared for things on the fly, that's what litigation involves. Most people who do administration don't have any of that.
So oftentimes people call or I'll see on the chat that people say, well, I need a probate attorney, and you dig a little deeper and you find out, well, I need a probate attorney because there's 5 siblings and they're all killing each other. They're all shooting each other and stabbing each other with knives, and so you need an attorney to get them through. Well, that's not just an attorney. That's by definition litigation. If they're fighting legally, that's what litigation really is. At what point do you see it kind of crossing the line of it being on your desk versus maybe your husband's desk? At what point, or on the intake of a case, what's kind of the criteria we say, well, that's a litigation? Everybody hopes their case is easy. Everybody thinks their case is easy when they start, I think, or most people do. But what's your experience on that? When's that cross the line and become litigation?
I think we can tell within the first 10 minutes when we speak with somebody whether or not that case is going to be just administration, or if it's going to result in people fighting with each other. Dynamics of litigation are usually who the parties are. Okay, are there, for example, siblings that have had a history of not getting along? That's one. Are there children from a first marriage and a second wife who have not gotten along?
That's always a clue.
Those are, and there's standard types of cases that end up in litigation, but children who often are trying to take, in conservatorships, children are competing with each other to take care of the parents, and sometimes that becomes a battleground. But we could tell. I mean, just because we've heard the patterns so many times, I think within 10, 15 minutes of a call with somebody, we can tell what we can expect, at least on our end.
It must be difficult to be in litigation and not bring it home with you. I know you have kids, you have a husband. So just speak as a businesswoman, how do you manage your health? I know it's an issue. I'm an affiliate member of the bar, and I see a lot of classes on, mental health and balance of life and such. Do you have any particular tips that you give? Because they're the same ones for us as real estate agents. Any particular tips on how to manage your mental health and physical health and all that family life as well?
Well, as far as family life is concerned, it's become more difficult since, many of us work from home now. So that, it used to be easy. You'd go to the office and then you'd clock out, and then you go to the grocery store and buy your groceries for the rest of the day and come and cook. So that used to be my routine. But now it's kind of like, it mixes itself in. So I have to, at some point, go to the office and then come back to the computer here. This is my kitchen right here. So it has changed. One thing that works for me, and I'm not sure if it works for everybody else, is gardening. Gardening really, really soothes you. I mean, if you go out in nature and do anything around anything that's green, it really changes the way you look at the world, and it takes down the adrenaline quite a bit. Yeah. So that would be my recommendation. But if somebody may do yoga, I do watercoloring, and that would be my son who just passed behind me to buy the birthday, by the way. But in terms of whatever works for you, anything that just takes your mind away. If you garden and you have to water the plants or clip the plants, it helps you kind of get out of your own head, so to speak.
I agree. Being outside and doing something vigorous. I do a power walk for about an hour every day, get sunshine, get some fresh air, and move around quite a bit, and definitely helps me keep my sanity. So, Colleen notes, I'm in California. Do we need to research your own state's procedures and processes? I'd say, Colleen, every state has different laws, and then every county has different procedures or rules. And so, to the extent you want to be an expert in your market area, I would definitely encourage you to learn the state laws as best you can and the local procedures in your county and follow those. Mina, you're licensed in California. Do you practice just LA County, Southern California, other counties, any other states?
I mainly work in LA County. I can work in all of California. Probate is pretty fungible, but most of my life experience has been here. I've appeared in San Francisco County, San Diego County, Orange County before, but my preference is for LA County, mainly because, you know, if you're familiar with the judges, it gives you an advantage in court.
Yeah, I've seen that about you. And I think, again, that's one of those things that you can't put that in your business card or your website, that you've practiced before all of or almost all the probate judges, and they know you, like you, and respect you. But I see that, and I've seen the value of that for you personally, as well as you were, you know, on the cases we were involved with. It's just interesting for anybody who's listening. I was thinking, you know, when as I was preparing for this, I've been both represented your client. I've also represented the buyer who bought a property of your clients, where they went into litigation or threatened litigation, whatever, conflict of some sort. So I was on with you. We were kind of against or on the other side. And then you referred me to somebody who's down the road, a past client who I'm working with as well. So I've really seen you from all three angles. I feel like I have a unique perspective of you. That I'm not just the happy client. I'm not just the upset party on the other end. I've actually seen it all sides. So I feel qualified to psychoanalyze you, I think, more than anybody else other than your husband or your
Well, I
your
hope
kids.
not. If you psychoanalyze me, I have some surprises.
Okay, so let's get into some procedural questions. One of the questions I got asked earlier was the difference. How would you summarize, if you're talking, of course you don't do administration, you do more litigation, but I'm sure at some point you talk to clients, how do you describe the difference between full authority and limited authority? I understand from the real estate sale, court confirmation or not, but what else is involved in the process that's different between full authority and limited authority?
So usually when you have limited authority, it implies that certain types of real estate transactions that you need to do, for example, exchange of sales, et cetera, require a court to bless that transaction. And what the difference between the two sometimes is the level of bond that a person posts. So if I have full authority, it's pretty much a simple transaction because I give what's called a notice of proposed action to the beneficiaries. I give them some time to let us know if they're going to object or not. And then if they consent or if they don't object, one or the other, then the transaction goes pretty much like a regular sale, very similar to a regular sale. But if somebody comes and objects, then I'm required to then take that to the court and say to the court, this person objects, but these are the terms. We think it's better for the estate to sell this property, for example, at these defined terms. And then the court can decide whether or not that's really in the best interest of the estate. And that beneficiary who objects gets an opportunity to come to the judge and say, hey, I don't agree with this. I think, they're underselling the property or the terms are no good. Sometimes, beneficiaries have different expectations, but most of these cases are well supported by appraisals by a probate referee who's the court's appraiser, and then by the marketing efforts of the realtor who is actually selling the property. So it's a mix of where those lines cross. Have you done enough marketing? Sometimes a beneficiary may have a point. We'll say, well, you sold this to the first person who came. That wasn't adequate marketing. That wasn't put on the MLS long enough. Those are sometimes issues that come about. Or sometimes there's a beneficiary that lives in the property and wants to delay that sale as long as they can. So what they do is they object, and then we go in front of the judge, and that's a couple more months, and then sometimes there's another couple more months. So that's sometimes how beneficiaries manipulate the situation. In whether or not it's limited authority or full authority, that can still happen. But the differences between the two are if people don't object or if they consent, that a full authority case ends up selling much faster and getting closed much faster so people
Right.
can get their money.
Right. And that's why I really encourage the attorney to follow the notice of proposed action right away once we have the terms ready to go, and then be ready to close right after that, because the longer it sits out there, the more likely somebody comes to the brother and says, hey, they sold it too cheap, and gives them more time to object. Whereas, there's a statutory limit. You have to give them notice. And at that point, they've kind of given up their right if they don't object. So I think speed is really important in those cases. Next question is one that's interesting. So I don't know that you know this, but I do know that you know Paul Horn, who is an attorney in LA County. And I don't know if you know that he teaches a class for the California Association of Realtors to certify agents. Not sure what the certification, it's not required. It's nice to have. And I think he does a good job of explaining the probate process. In that class, he teaches that while you can't sign a binding contract until the letters of authority are issued to the estate, that one can sign a non-binding listing agreement, and as long as you disclose to all the parties that it's not binding. So if I had a family member who's filed a petition to be an administrator or executor, I can sign. He would say you can sign a listing agreement that says, oh, by the way, this isn't binding. This is just more advisory. Once you get the letters, we have to get everything re-signed. Some companies allow that, some don't. So it varies on your broker and your company policy and such. As an attorney, how would you advise a client who was anxious, they want to get started, they're nervous, maybe there's a foreclosure, they're not paying the mortgage, it's vacant, they have problems with squatters, they want to get it done quickly, but you got to get it done legally. Would you advise and approve them or encourage them to do a contract with those disclosures to get the process started, or you think that's just too aggressive and you should wait till letters are approved?
I don't do it that way. Everybody has their own way. And the reason why I don't agree with that is this. Let's just say that, Bill, you came to me and you said, I want to sign a non-binding contract with you. My client who is hasn't become the administrator yet, doesn't have any authority to bind the estate. So that's one. Number two is, let's just say you sign a contract with somebody who would be administrator. How would either party enforce that contract? By its sense, non-binding means it's not really a contract.
Right.
So that, and I know realtors often like to help, and I know they want to help with the cleanup of the property, et cetera, et cetera. But how do you achieve the result that you want and not have any risk? As a realtor, let's say you advance the cost of junk removal, okay, before the administrator is appointed. Okay. Isn't there something that the administrator can, the day after they're appointed, can't they actually change their mind and say, you know what?
Yeah.
My next door neighbor said he's going to come and haul everything away. Meanwhile, you've paid a junk removal company. How do you enforce that? It's a non-binding agreement. How do you go about doing that? So, it gets kind of murky. Everybody has their own comfort level of advising people. My advice is just, have the relationship with the prospective client in the sense that they will trust you and sign with you as soon as letters are issued.
Right.
And I think I think Paul probably is encouraging you to develop that.
Yes, for sure.
Yeah.
He just lined out the process. And of course, real estate agents hear, I could get a listing, I'll do it right away. And I think sometimes we have to think through like you just pointed out, if you think through the whole process, does that really make sense? And maybe it does in a rare case, but generally speaking, it can be difficult. It depends on the circumstances, I would think.
So when you sign the listing agreement, and I'm assuming that your listing agreement usually requires the person who signs it to be the administrator of the estate of the decedent.
Correct.
And when they're not appointed yet, when letters have not issued, they don't have that title.
Correct.
They don't own the property that you're trying to list,
Correct.
right?
Correct.
So it can create a lot of problems. It's like you sign an agreement with me to sell my next door neighbor's property. I don't own that property, right?
Well, there's another issue with it too also, which is if an agent does sign the listing agreement and puts in the MLS, which I guess, again, legally the MLS will allow it as long as you disclose to not just on your listing, but to prospective agents. By the way, this listing isn't binding, it's pending, letters of authorization.
Right.
There's nothing preventing a realtor from calling the client directly because technically you don't have a binding contract. So they could call the attorney or call the client and say, hey, your listing's not binding, I'll do it for less or I'll do it better. And you kind of put a target maybe on your back if you have the right relationship.
I think it creates an ethical issue too, because the other realtors can pick up the phone. You don't represent the administrator. You represent the person as an individual. So isn't there something that I know realtors have these rules of ethics that you're not going to go after somebody else's client, but those are two different capacities. Correct. You coming to me to sell my house is different than you coming to sell a house where I'm named as an administrator. Those are,
it's not simple for sure. And I think, again, he describes legally, could you do that? I guess you could do it, but I think there's complications and risks and something you have to kind of think through. So, okay. So just to kind of circle back a little bit, Chris asked a question, what's a usual probate litigation matter? I think the answer is going to be none are usual. That's the nature of why you do it. They're all a little different. They're all a little wacky and have their own unique twists on it. But you tell me, if somebody said, what's the usual probate litigation matter that you handle? What is the most common?
Most common is an undue influence case. Second most common is a forgery case.
Ooh. Oh, okay. Hold on. This is interesting now.
There's a lack of capacity case.
I didn't realize. I don't see as many of those as an agent. So let's talk about that. So undue influence, let's talk about that. What does that look like? And how would maybe a realtor notice that and maybe flag that to the family or flag that to an attorney?
So an undue influence case is one where someone has, on a repeated basis, try to get someone to take a particular course of action. In wills and trusts, it's fairly common, either to sign a will, a trust, a codicil, or an amendment. Honestly, it's a psychological game where people try to be kind to somebody and try to get them to take a certain action, or they badger them in order to get them to, take care of something, or they control their food, their right to sleep. Sometimes it's caregivers, sometimes it's family members. 90% are family members. 90% influence, comes from relatives. Sometimes they're from girlfriends. It varies from case to case.
And so the girlfriend or caregiver or family member who's living in the house with the person who ends up passing at some point brings them a will or a change to their trust, and instead of giving everything equally to 5 siblings, give everything to my favorite sibling, Joe, who happens to be the caregiver, or give everything to my caregiver, Marianne, or my girlfriend, so-and-so. Is that what we're talking about?
Sometimes a child lives with the parent. Sometimes a child doesn't live with the parent, but is the main caregiver.
Right.
Comes to parent's house every day, and the parent sees that child as sort of their lifeline.
Right.
And so the child, gets to be in the position of power. I hate to say that, but that's really the truth. Power over the parent so that they can overpower their own judgment, essentially.
Right. So there's probably some cases where that's a reasonable transaction in a sense, right? You're taking care of me at the end of my life. My other kids abandoned me. I can only live really with your help. And as a result of that, I want you to have this. I can imagine somebody of full, mind might make that decision in certain circumstances. But I think what you're talking about is when it's not the case and during undue influence, hey, you need to sign this if you want me to continue. How do you prove that? What's that look like as a legal matter?
Undue influence is a very difficult thing to prove, but there are methods of proving them up. They are never proven by direct evidence. They're always proven by what's called circumstantial evidence, evidence that's surrounding a particular set of facts, not the facts themselves. So it could be that, for example, mom had the beginnings of dementia and was becoming more dependent on child number one, for example. Then, or some of those circumstances, and did the child, for example, accompany them to an attorney's office? Did they make the appointment? Did they pay for the appointment? There's a lot of things around the actual change of the document that are more relevant than the actual document themselves. But they're not easy cases to prove, but they are doable. They go to court often. Sometimes they're combined with lack of capacity. Sometimes they're not. Sometimes they're just straight undue influence. Sometimes they're mixed with elder abuse. Elder abuse often comes in on the side of undue influence as where a child was isolating a parent, or the person who benefited from the circumstance isolated them. Sometimes the isolation is so subtle that you have to kind of put together the facts of, who saw the person, did anybody see this person, or was the person who passed away someone who didn't have many friends. Sometimes people who don't have many friends are easier to influence.
Of course.
And those are indicators that the judges look for. But in California, we have some really terrific case law that tells a story of undue influence, of how these people, influence this person. One was they influenced them in all aspects of their life, trying to get them to sign a promissory note. If that didn't work, they try to take them on lavish vacations in hopes of getting them to agree to sign something.
Wow.
But those are the things that you look for. I mean, and it's hard for realtors to get that, but if you've seen it a few times, you will know, how it works.
It's subtle, and that's why it's litigation. It's not a filing. It's not a form. It's a process of
Right.
litigation that you're involved with. The other one that we deal with and come across from time to time, and I'm aware, we have about 5 minutes left here. I want to be sensitive to your time, and I appreciate your time. I really enjoyed this. One of the things we come across with as well as realtors is diminished capacity, right? At what point is somebody signing something that they don't really, even maybe with good intentions, they don't really understand what they're signing. Tell me about that. Is that more common now? I would imagine there's more people with memory issues and Alzheimer's than ever before. Is there more litigation in that area as well, or how does that get handled?
Yes, lack of competency is a big issue. It's not just specific to wills and trusts, but it also goes to other contracts for sale and the listing. So you have to start, when you list a property, you want to make sure that the person you're actually signing the contract with knows the consequences of that agreement and can repeat it back to you and communicate it back to you. Yeah. If you have doubts, don't do it. If you have doubts, go to your broker and say, hey, I have an issue with this one. What do you think I should do? But it's fairly common that a person signs a listing agreement and they don't understand it. I had this case actually go to litigation where a woman who had Alzheimer's disease had signed a real estate agreement. The person who was buying the property from her had essentially tried to unduly influence her by offering to give her $100,000 outside of escrow. He did. He actually paid her $100,000 outside of escrow. And he basically had said, you move out and you've got this 100,000. Well, she received the 100,000, but didn't move out. She wasn't there. She wasn't altogether there. Wow. And then about a year later, when she couldn't perform, she wasn't able to really carry out the transaction in any way, he sued her. And when my client was a professional conservator who came in. I was handed a lawsuit that said, he's getting a default. So the actual buyer was in the process, had already gotten a default, and I had to go in and set aside the default, explaining to the court that she was incompetent, essentially.
Wow.
So it did end up settling, but it was a very difficult case, stressful because, she could have lost everything.
Wow.
But well.
I mean, when the first listings, I was so excited. I called the guy on the phone, and just as we practiced it, he agreed to everything, agreed to the appointment. I went out there. I went to the presentation. I was taught to get in and out if they're ready to sign, get them to sign. And I got a phone call from a real estate agent who was working with the attorney. And he said, didn't you realize that he was just, overly agreeable? I said, well, now that you mentioned it, I was excited to go out there, and that's my job. But now that you say that, he said, well, you're probably about the 8th or 9th realtor he signed it with. He just likes talking to people on the phone. He's lonely. And if you offer to come to his house, he's glad to meet with you. And if he likes you, he'll sign whatever papers you give him, but he doesn't know what he's doing. And there's litigation going on. And just so you know, that contract's probably not binding, but you can do whatever you want with it. And I ended up walking away from it. But I learned a lesson, which was slow down and pay attention, because I wasn't aware. But these issues, I think, are becoming more regular for us as realtors, and we have to make sure that we're on board. What we don't want to do is get a listing and then have family members call us and accuse us of elder abuse or taking advantage of their clients, and we have to be sensitive to those questions.
We have a question sometimes that we ask our clients is, have you met with many other attorneys before you talked to me today? Mm. And that answer actually makes us think more about whether or not we want to take on this case. Sometimes clients have gone to 6 attorneys and it didn't work out for whatever reason.
Right.
And I think realtors could do the same thing. I think you could ask a client, A, have you signed any agreements with any other realtors about this property? Right. And how many realtors have you engaged with respect to this property? That will give you a good frame of mind as to, whether or not, you want to take on that case, or whether or not you should take that case, depending on other circumstances. I know you guys are laughing because you think, realtors, when I go to hire a realtor, I might meet with 5. When I go to hire a lawyer, I might meet with 3 or 2, however. But those facts that come out of that answer lead you to other questions that you may want to consider before you take the case on.
I think the other thing is networking in your case, knowing the other attorney is if somebody comes to you and they've talked to somebody else, you kind of know who they are. And if they're somebody who's solid, that's going to be a big red flag. If they describe what sounds like incompetence and it's somebody, and you notice they don't know what they're doing. I've seen cases where the attorney's older than me, and I can search the probate case files. He hasn't done one in 5 years. Okay, the customer, I'm inclined to listen to the client a little bit more than somebody who, if he calls and says you're the attorney, I'd call you up and see what the problem was and see if I could help somehow. So it's different. Look, we're over time. I could talk to you for hours. I still remember going to lunch with you pre-COVID, and you introduced me to one of the great restaurants in the Valley. But I really appreciate our time so much. I appreciate the work we've done.
Thanks for having me.
But let's do a quick commercial, though. If somebody wants to get a hold of you, your best place, SirkinLawGroup.com. Is that the best way to reach you?
Yes, that's the best place. And,
okay. And in the website, yeah, and they are. And there's a phone number there, 818-340-4479. And she's got a crack team. Yes. I called today. And they got
That's the best number to reach.
Good. Okay, good. And you'll notice, I think one of the things I always say, when I go to the attorney's website, and here's a case, perfect one, what do? They do probate. They do, if you hit practice areas, they do probate, trust litigation, wills, contests, ancillary probate, foreign wills. Basically, it's all related to this area. This is why she and her husband are experts in this field, and that's the kind of attorney that you want to work with the administration. You'll kind of get pushed to her husband, Evan, and if it's a trust litigation, unfortunately. But the good news is you'll work with Mina. Mina, thank you so much for your time today. I really appreciate it.
Thank you very much. I appreciate you having me. Appreciate it.
And for the rest of you, got some thank yous there. And for the rest of you, this is Probate Weekly. We do it every Thursday, 4 p.m. Pacific, 7 p.m. Eastern. We live stream as well to YouTube and Facebook. We had a ton of questions today that I couldn't get to because I got caught up. I tried to answer some of them as we went through with her and rephrase some of them. I'm going to download the chat. If you have questions, I saw Elizabeth in particular. Love to chat with you about that, about how to get business and things like that. Just this wasn't the right person or day for that, and I really appreciate a chance to get in deep with Mina on the business. But I'll do my best to reach out if you have some questions there. Reach out to me directly, either in the chat box, reply to the emails you're going to get here today, or call or text me, Bill Gross. I am the LA Probate expert, and look forward to seeing you guys soon. Thanks so much. If you like this, like it on the YouTube if you're watching on YouTube, and thanks for your support.